Three people, three different New York boroughs. Three moments when someone in a position of power looked them in the eye and told them the door was closed. A property manager invoked the weather. A doctor delivered a terminal diagnosis, and an attorney followed it with the word time barred. Three delivery company legal teams sent three separate letters confirming three separate reasons why none of them owed a single dollar. In all three cases, the person getting the bad news was betting on the same thing, that the person on the ground didn't know what the law already said. A 71-year-old grandmother, a 61-year-old retired teacher with mesothelioma, a 45-year-old accountant who read the denial letters carefully and almost believed them. All three found attorneys who knew what the law actually said. The property manager was wrong. The first attorney was wrong. All three delivery company legal teams were wrong. Combined settlements? $4,660,000. This is state law exposed. Dorothy Ramirez was 71 years old, retired, and had spent her career feeding children in a Bronx school cafeteria. On a February morning in 2026, she was walking 2 blocks to the bodega on Morris Avenue when she hit black ice on the sidewalk directly in front of a privately owned apartment building. The fall took less than a second. She went backward, hit the ground, fractured her wrist, and sustained a traumatic hip contusion serious enough that walking would require 4 months of recovery. She lived alone. The fractured wrist made making coffee, opening doors, and getting dressed suddenly impossible. The property manager appeared within minutes, which in retrospect suggested someone had been watching for exactly this outcome. His position was delivered quickly and with practiced certainty. There's nothing we can do about black ice. Ice after a storm is an act of God. No one is responsible for that. He said it like a man who had said it before. Dorothy had no reason to disbelieve him. The first attorney she called told her these cases were hard to win in New York. Both of them were wrong. New York City Administrative Code, Section 7 to 210, is one of the most consequential sidewalk liability statutes in the country. Before 2003, New York City itself bore liability for most sidewalk failures. After 2003, that liability shifted to adjacent property owners for most non-municipal properties. The mechanism is precise. NYC Administrative Code, Section 16 to 123, establishes 3 specific time windows. If snowfall ends between 7 a.m. and 4:59 p.m., property owners must clear the sidewalk within 4 hours. If it ends between 5 p.m. and 8:59 p.m., they have 14 hours. If it ends between 9 p.m. and 6:59 p.m., the sidewalk must be cleared by 11 a.m. the following morning. Miss the applicable window and you have created a rebuttable presumption of negligence. The property owner then bears the burden of proving they acted reasonably despite the delay. Black ice that forms from uncleared snow or from inadequately cleared snow that refreezes falls squarely within that duty. The act of God defense, legally meaningless once the snow stopped falling and the 4-hour clock began, an act of God creates the hazard. The law creates the duty to respond to it within a specific window. Dorothy's attorney started with weather records. National Weather Service precipitation logs confirmed snowfall at that location ended at 9:47 a.m. Dorothy's fall occurred at 3:52 p.m., approximately 6 hours after snowfall stopped. 6 hours. The 4-hour window had expired 2 hours before she ever reached that sidewalk. Building inspection records showed no snow removal had been logged for that property on the date of the incident. Then the attorney found something the property manager had not anticipated. A surveillance camera on a neighboring hardware store had captured continuous footage of that stretch of sidewalk. At 2:15 p.m., 97 minutes before Dorothy fell, the camera showed the sidewalk completely untreated. No salt, no sand, no evidence that anyone had touched it in the 6 hours since the snow stopped. The property owner's insurer settled for $285,000. Wrist surgery, physical therapy, pain, and suffering. The act of God defense never appeared in the settlement paperwork because it was never a defense. It was a line the property manager had been trained to say to people who didn't know the law. The distinction the property manager was banking on between weather creating ice and negligence, maintaining ice, doesn't exist in New York law the way he described it. The weather creates the initial hazard. The law creates a duty with a specific deadline attached. A property owner cannot avoid liability by pointing at the sky if 6 hours have passed and the sidewalk remains untreated. The law anticipated exactly this argument when it was enacted in 2003 and built the rebuttable presumption specifically to shift the burden onto the party with the ability and the legal obligation to act. The broader lesson of Dorothy's case is not just about snow removal. It is about how institutional actors use confident-sounding legal misinformation to discourage claims they know are viable. The property manager knew the building's maintenance logs showed no snow removal. He invoked act of God because it sounded definitive to someone in pain on a sidewalk. It was not definitive. It was a calculated bet that Dorothy would never find out what the law said. James Whitfield spent 28 years in the same pre-war apartment in Upper Manhattan. He watched his neighborhood change twice, outlasted 3 building management companies, survived 2 major renovation projects. In November 2025, at 61 years old, he received a mesothelioma diagnosis. His pulmonologist walked him through the pathology with careful precision. The cancer was caused by asbestos exposure, most likely from deteriorating pipe insulation and floor tile adhesive throughout the building's common areas in his own unit. The building had been renovated multiple times between 1987 and 2008. James had never been warned about asbestos. He had never seen an air quality test result. The landlord had collected rent from him for nearly 3 decades. He called an attorney. The attorney told him 2 things. Asbestos lawsuits were basically over, and the case was probably time-barred because the exposure happened decades ago. Both statements were wrong. That James, facing a terminal diagnosis on a timeline no longer measured in decades, almost believed the first attorney and walked away. New York CPLR Section 214C establishes a discovery rule for latent injuries caused by toxic substance exposure. The 3-year statute of limitations does not begin to run at the moment of exposure. It begins to run when the plaintiff discovers, or reasonably should have discovered, the injury and its causal connection to the toxic substance. For mesothelioma, where the latency period between asbestos exposure and diagnosis spans 20 to 50 years, this means the clock typically starts at diagnosis. James's exposure may have begun in 1987. His limitations period began in November 2025. He had 3 years. The first attorney's analysis was not just wrong, it would have cost James everything. The second thing the first attorney said, that asbestos litigation was basically over, is simply not accurate in New York in 2026. New York City's Supreme Court maintains dedicated asbestos litigation courts specifically because this litigation continues, because the city has a unique concentration of pre-war building stock, and because there remain multiple viable defendant categories with real insurance coverage. James's attorney identified 3 viable defendants. First, the current building owner for negligent maintenance of asbestos containing materials and for failure to warn tenants under EPA hazard notification requirements prior to renovation. The building owner had a specific regulatory obligation to notify James before renovation work began. That obligation was never fulfilled. Second, the corporate successor of the renovation contractor who performed the 1998 renovation work, the job that an industrial hygienist later testified had disturbed friable asbestos without the required EPA NESHAP containment procedures. That violation was not a technicality. It was negligence per se under OSHA 1926.1101. Third, a former property management company that oversaw the renovations without proper EPA compliance. Additionally, asbestos bankruptcy trusts, established by manufacturers who went bankrupt under litigation pressure, continue to pay claims in 2026. They are not out of money. They are structured payment systems with specific claim criteria. An experienced asbestos litigator knows which trusts remain funded. James's attorney knew. James filed in New York Supreme Court's asbestos litigation part in early 2026. The industrial hygienist testified that the 1998 renovation had disturbed friable asbestos, the kind that becomes airborne and inhalable without required containment procedures under EPA NESHAP standards. The building owner's failure to provide EPA-required hazard notifications to tenants prior to renovation created a separate and distinct negligence theory. James had never been told. He had a right to be told. The law required it. The case settled through a combination of defendant settlements and asbestos bankruptcy trust claims for $4.1 million. The first attorney's limitations analysis was not just wrong, it would have cost James $4 million and his ability to fund his own treatment. The discovery rule under CPLR Section 214C meant that James's 2025 diagnosis, not his 1987 or 1998 exposure, had started the clock. He had 3 years from November 2025. He used them. The latent injury discovery rule under CPLR Section 214C exists because the law understands something fundamental about toxic exposure. You cannot file a lawsuit for a cancer you don't know you have. Courts have repeatedly confirmed that this rule applies to asbestos, to lead paint, to contaminated water exposure, and to other toxic substances whose harm manifests over years or decades. The clock starts when you discover the injury and its causal connection to the substance. James discovered both in November 2025. The broader implication of James's case is this: anyone who has ever lived or worked in a pre-war New York building that underwent renovation without proper asbestos abatement, and who later developed a respiratory illness or cancer, should not assume that the statute of limitations has run. For latent diseases, it almost certainly has not. The question is not when the fiber was inhaled. The question is when the disease was diagnosed and its cause identified. That is the question CPLR 214C was written to answer. Grace Kim crossed Broadway on the Upper West Side on a May morning in 2026 at the intersection she had used every day for 9 years. The light was in her favor. She had the walk signal. She was in the crosswalk. None of that mattered when a Class 3 e-bike, the kind that reaches 28 miles per hour, came through the intersection on an active delivery and struck her. Fractured wrist, arthroscopic knee surgery required. $68,000 in medical bills. The rider had no personal auto insurance. The restaurant's general liability policy contained a motor vehicle exclusion. The delivery platform's terms of service disclaimed all liability for worker conduct. The restaurant is a customer, not an employer. The platform is a technology company, not a transportation company. Everyone is something other than responsible. Grace's surgical recovery was 4 weeks of non-weight bearing, followed by 6 weeks of physical therapy. She could work remotely, which was fortunate. She could not ignore $68,000 in bills, while 3 well-funded legal teams confirmed they had no obligation to pay. New York State Bill S139B, proposed in 2025, would require delivery platforms to carry mandatory liability insurance for pedestrians injured by their workers. But, as of 2026, it remains unenacted. The legislative gap means victims pursue liability, and the other theories exist. The most powerful theory for delivery liability in New York is the retained control doctrine, the same doctrine being used by Amazon's DSP. Under Kleeman v. Reingold and its New York progeny, an entity that retains operational control over a worker's performance can be found vicariously liable even when the worker is formally classified as an independent contractor. Delivery platforms run apps that track every rider's location, speed, and delivery status in real time. They set the routing, they enforce quotas, they sequence deliveries. That is operational control, regardless of what the terms of service say the relationship is. A second theory is negligent entrustment. If the platform provided the e-bike and knew, or should have known, that the rider was operating it in a manner likely to cause injury, the platform may bear direct liability for the equipment it supplied. Neither theory requires an enacted insurance mandate statute. Both theories exist in New York case law right now. Grace's attorney knew both of them. Grace's attorney filed in New York Supreme Court, New York County, against the delivery platform directly, arguing retained control through the platform's GPS-enabled app and negligent entrustment through the company-provided e-bike. Through CPLR discovery, counsel obtained 2 critical documents that the platform's terms of service disclaimers could not override. First, the platform's GPS records confirming the rider was on an active delivery at the exact moment of impact. Second, the platform's commercial liability policy, which contained a blanket coverage provision for incidents involving contracted workers while on active deliveries. The platform's insurer, faced with GPS evidence confirming active delivery status and a retained control argument grounded in the platform's real-time monitoring system, paid $275,000. Grace's medical bills were covered. Her lost income was recovered. Her surgery was funded. The 3 carefully drafted denial letters never mentioned that a CPLR Article 31 discovery subpoena could reach the platform's own insurance policy. They were not required to mention it, but it was always there. The lesson from Grace's case is not that a specific insurance mandate saved her. It is that the retained control doctrine, combined with aggressive CPLR discovery of the platform's own insurance coverage, can reach through the liability wall that delivery platforms spend considerable resources constructing. Every major delivery platform operating in New York City runs a GPS tracking system that documents exactly what every rider is doing at every moment. That GPS data is discoverable under CPLR Article 31, and in cases involving active deliveries at the time of injury, it is the most powerful exhibit in the case. The law is catching up to this industry, slowly and through litigation rather than statute, but it is catching up. The pending S139B legislation, if enacted, would add a statutory insurance mandate on top of the common law theories. Until then, the retained control doctrine is the tool. Grace's case proves it works. The platform's GPS confirmed active delivery. The platform's own insurance policy confirmed coverage. 3 denial letters met 1 discovery subpoena, and the denial letters lost. Episode 5 is fundamentally about time, about who controls the clock and when it starts. Dorothy's case involved a clock that ticks from the moment snowfall stops, 4 hours, and then the liability belongs to the property owner, not the weather. James's case involved a clock that most people think has already expired before it has even started. The 3-year limitations period that begins not at exposure but at diagnosis, the moment you discover what the substance did to your body. Grace's case involved a clock running in real time inside the delivery platform's own servers, the GPS timestamp confirming active delivery status at the moment of impact. 3 different mechanisms, 3 different bodies of law, 3 different ways that time becomes the argument that either builds or destroys a case. What they share, in each case, the person adverse to the claimant was betting the clock had already run. In each case, the clock was actually running exactly as the claimant needed it to run. The only variable was whether they knew it. There is a pattern across all 3 stories in episode 5 that deserves naming directly. The property manager who invoked act of God knew the building's maintenance log showed no snow removal. The first attorney who told James his case was time-barred, either did not know about CPLR 214C's discovery rule or did not specialize in asbestos litigation, and should have said so. The 3 delivery platform legal teams who sent denial letters knew their own commercial liability policy existed and knew that CPLR discovery could reach it. In each case, the person delivering the bad news was not delivering a neutral assessment. They were presenting the most favorable reading of the law for their own position, using language confident enough to close the conversation before it could begin. The difference between the thousands of New Yorkers who accept that conversation as final and the 3 people in this episode is not luck. It is access to someone who knew what the law actually said and was willing to push back against practiced institutional certainty with documented fact. NYC Administrative Code, Section 7-10, transferred sidewalk liability from the city to property owners in 2003. Section 16 to 123 attached specific time windows to that obligation. 3 different deadlines depending on when snowfall ends. The combination of these 2 provisions is what defeated the Act of God defense. CPLR Section 214C established the latent injury discovery rule, the provision that moved the limitations clock from exposure to diagnosis for toxic substance injuries. That single section of the civil practice law is what separated James from losing everything versus recovering $4.1 million. The retained control doctrine, grounded in Kleeman v. Reingold, extended vicarious liability to entities that exercise operational control over workers regardless of how those workers are formally classified. That common law doctrine, combined with CPLR Article 31 discovery procedure, is what opened the delivery platform's commercial liability policy. 3 bodies of law, 3 stories. 1 consistent principle. New York quote the protection. The people who needed it just needed someone to show them where to find it. $285,000. $4,100,000. $275,000. Total, $4,660,000. These are not lottery numbers. Each one is the calculated value assigned by opposing insurers and legal teams to the cost of their client's documented violation of New York law. The property owner's insurer paid $285,000 because a weather record, a building inspection log, and a hardware store's security camera documented a 6-hour failure to comply with a 4-hour legal obligation. The combination of building owner, renovation contractor successor, property management company, and asbestos bankruptcy trusts produced $4.1 million because an industrial hygienist documented a 1998 renovation that distributed carcinogenic fiber without required containment, combined with a 3-decade failure to warn a tenant who had the right to be warned. The delivery platform's insurer paid $275,000 because GPS data documented active delivery status and a CPLR subpoena reached the commercial liability policy the disclaimer letters never mentioned. None of these outcomes required extraordinary facts. They required someone who knew what the law said. The people in these stories did not win because they got lucky, or because they found unusually sympathetic juries, or because they had connections. They won because they found attorneys who knew what the law already said. Before the case was filed, the jury was sent. Before the first letter landed on the lawyer's desk. The act of God defense sounds definitive until you know about the 4-hour clock. The case too old line sounds authoritative until you know about the discovery rule. 3 denial letters sound comprehensive until you know about the retained control doctrine and the CPLR Article 31 subpoena. New York wrote these laws because the state decided, after seeing the harm created by their absence, that property owners, toxic exposure defendants, and delivery platforms should bear specific, documented obligations to the people affected by their conduct. The laws are in the books. They have been there in some cases for more than 20 years. State Law Exposed will keep telling you what they say. Every single week. Real law. Real money. Real New York.